the cap issue is something I effectively deal with post-judgment, assuming we ever get there.
Correct. The statute requires findings, fact findings by the finder of fact is what it says in the statute, I believe.
So why is it not better for us to put the questions in there, see what the jury does, and then if there's a question of it wasn't properly pled, I can always deal with it after the fact. And I think I understand precisely that the defense is saying it should not be on there in the first instance at all because it wasn't pled and have no formal notice.
If we had known that they were going to try to beat the cap, I thought maybe they would try to do that on child abuse when they put in the language on sex battery that got stricken, but I frankly was not anticipating that they were going to do this, and these are things that would have impacted how we presented the case. So I don't think it should go in for that reason, but I also don't think this has been proven. And
well, certainly there's a portion of this case that we would have to have if there were a finding of punitive damages in phase one. So the defense would still have an opportunity to present evidence.
Yeah, but the notion, using, for example, the EEG room, that we had a specific intent to harm her by moving her down the hall to go into that room, is there really evidence of that?
Well, my inclination is to put the questions on there, and then if we ever get there, deal with whether this was properly pled later.
Okay.
I would hate to have to just do this whole thing over because we didn't ask the question of the jury. And if it doesn't effectively change anything as it relates to what we're asking the jury to do, then I'd rather just ask the questions. I think that's consistent with my approach to the entire case. So I want to do that. Now, how about the actual jury instruction language? Is there agreement on what Mr. Altenburn sent around? Are there additional items that need to be addressed? And certainly I need to see it sooner as opposed to later. Hey, Nick, are these
Let me get. I think we would need to obviously have a question. Or maybe we don't. Maybe we don't need an instruction. Maybe that's apparent from the question. But I don't have Mr.
Yeah, these instructions do not include. I think there's something that needs to be added if you're going to put the specific intent question on this, because I used language from the standard instruction in A and B. I think maybe that is in C or D. I've got the form here. I can look.
The jury is here now.
But one way or the other, it may be missing some factor for that.
Okay. Well, Mr. Elliott, I know you said you have an oral argument in front of the District Court of Appeal this morning. Is one of your law partners able to pick this up? Because I really need this language sooner as opposed to later.
Yes, and we have sent a set. I can't, since I'm on my phone, I can't call up the set and see what's going on at the same time. Maybe Mr. Altburn, the set that we sent the other day, does it have the instruction in it about intent? I can't get it in front of me right now.
I don't know if he does.
Well, let's put it, we don't need to, Your Honor. Yes, we'll look at. We have other folks that can look at this, and Ms. Lawrence and the team have a copy of what was done yesterday or the day before, and so they can also look at that and forward it to the court.
Okay. Sooner as opposed to later, please. Thank you. Now,
yes.
And Mr. Elliott and Mr. Altenburn, I did, and I don't know if this was intentional or just as we were going through the form, I didn't see the standard instruction that says you may, in your discretion, decline to assess punitive damages. Maybe I just misread it, but was that something that we need to put in the? It's
Your Honor, that's.
So go ahead, Mr. Elliott.
That's in that instruction is in the phase one that you've already given, I think, and then the way they deal with it in phase two, and it's a little. I will agree. It's a little tricky the way they have it worded in the official or in the standard verdict. But when you get to phase two, the way it's worded, it talks about that you may have decide the amount of punitive damages, comma, if any. So the if any that's in each of those questions takes care of that.
Well, but I would tell you, though, that language is a standard within the opening instruction second stage portion.
Okay.
So,
Okay, I thought you were talking about the verdict form. I'm sorry.
no, on the actual language. So it's under the little section that says refer to note 8 refer to note on use 8. So maybe y'all can just look at that and if it needs to be added in there. And then also, do we need a non-duplication instruction? Maybe it will be mooted out by what happens.
Right, I put a non-duplication on the verdict form, but I didn't put it in the instruction.
And I will tell you, I am leaning, and I certainly would listen to both sides, but I am leaning towards, if the jury finds both battery as it relates to the photography session and false imprisonment as it relates to the photography session, to combine those as a punitive damage for that issue. I mean, that's how I'm leaning right this second. And I think that kind of obviates the non-duplication issue, but
The defense would not object to that.
I didn't think you would, but
It's just simpler.
just to let you know, that's where I'm leaning. So I'm going to turn that back over to the lawyers to get those documents to me as soon as possible. I understand we have the jury here, so are there any issues we need to address before we let the jury start to begin their deliberations?
No, Your Honor.
Let's bring in the jury. And Madam Clerk, if you can please take the evidence. Okay, please be seated, everybody. Members of the jury, good morning. Good morning. And thank you again for being here early. I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that all correct? Correct. And that's obviously since we broke yesterday from your deliberations. Is that correct? Correct. Okay. And has anyone approached you at all about this case? No. Have any of you seen any media accounts about this case? No. Okay. I've just asked the clerk to go re-deliver the evidence to you. I just heard the door close, so they're in the process of doing that. Let's talk logistics for a moment. Timing-wise, you all are, whatever you all do is going to be fine from a timing perspective. Remember, if you wish to continue to deliberate after today, we will have to bring you back on Monday. The courthouse is closed in honor of Veterans Day tomorrow. So if we're not finished with our work, we're going to bring you back next week. Okay. Anyone have any questions about that or concerns or anything like that? Okay. What I'm going to do is I have the sealed envelope. It does not look like it has been damaged in any way. Do the attorneys wish to look at the seal or anything like that? No. Okay, I'm going to hand the sealed package back to the jury, and we're going to let you recommence your deliberations, and we will await your question or verdict. Okay, you may begin deliberating.
All rise. Jurors exited.
Thank you. The jury's out of our presence. Please be seated. Obviously, we don't know from a timing perspective what's going to occur. I would ask, if you leave campus, try not to go too far so that when we have a question or a verdict, we can reassemble. I've got other things I'm working on this morning, but I will, as soon as we hear, I'll try to wrap up whatever I'm doing at that moment and come and address this case here. Any questions?
If you want me to, I can go back to my office, away from my office, and add that paragraph. I've been working off the draft that the plans gave me, and it's missing, and I can take a look to see if there's information that needs to be added for the specific.
Yeah, it might just be a sentence, whatever Mr. Altenburn you want to do. And maybe the lawyers need to have their witnesses for punitive damages available and ready to go. Because from a timing perspective, if we're trying to land this today, if there's a finding of punitive that we have to go into phase 2, I'd like to be able to turn it as quickly as we possibly can. But obviously it depends on when. Okay, we will be in recess pending the call of the jury. Okay, thank you.